56406, Charles J. Sebesta, Jr.
The board. The issue presented today to this board is whether the bar's determination in 2007 that there was no just cause to proceed on a complaint against Mr. Sebesta arising out of the underlying criminal trial of Mr. Graves precludes the bar from further prosecuting the 2014 complaint against Mr. Sebesta arising out of the same issues. And this is a purely legal question. It is not dependent on the facts of the underlying trial or Mr. Sebesta's conduct as a district attorney prosecuting a criminal case. But it's an important issue for this board to address because in order for the grievance and attorney discipline system to function properly, it's critical that the bar apply the disciplinary rules fairly and consistently in every instance regarding every respondent attorney, regardless of the specific factual allegations against them. This is a fundamental premise of the rule of law. Everyone is entitled to a fair and consistent process in compliance with the applicable statutes. Indeed, when the allegations against a respondent attorney are serious, it's doubly important that this body ensure that the bar comply with the applicable procedures, because the bar cannot have a second class of procedure for respondent attorneys that it perceives to be bad guys. And so we respectfully submit that this board should reverse the judgment of disbarment against Mr. Sebesta because the 2007 determination of no just cause was a determination under the applicable statutes. It was intended by the statutes to be final, and it precludes the further prosecution that's at issue today.
Ms. Weber, go ahead.
You say it's intended to be final. Tell me what support you have for it, that you say it intended to be final, and what you mean by that.
Here's what I mean by that, Chairman Kittner. In 2004, there was an omnibus and really very complete amendment of the applicable disciplinary rules. And that amendment took what had been kind of a squishy set of standards of what the CDC does in the investigative arena and divided it up into very particularized stages with particularized mandatory time deadlines and mandates to the CDC to conduct those procedures within the time. And I filed previously, and I think you have there on the bench a packet. These are all items that are in the record. These are the series of correspondence dealing with the 2007 grievance procedure, and these illustrate first how the statute is supposed to work and the hallmarks of finality, and second, why the 2007 proceeding precludes the 2014 proceeding on the same.
Ms. Weber, I want to try to remove issues that may not be critical to your argument, and let me just ask you this example. Let's suppose that in 2007, there were a determination of no just cause by a summary disposition panel based on whatever information had been gathered at that point. Assume that 3 months later, still in 2007, greater quantities of information were determined, perhaps even including inaccuracies in the initial portion. Is your view that there would be no power to proceed on the new information because there had already been a determination of no just cause for that transaction?
Yes, Mr. McKetta, that is how the statute is structured.
So that's critical. So the limitations issues are not part of are not material to your argument unless they relate to adjudication and such.
I do not believe that limitations is material.
The pleadings you have of res judicata, equitable estoppel, and quasi-estoppel are the affirmative defenses. There is no pleading of limitations as such in your papers.
Correct.
Okay. If there is an evidentiary panel that makes a determination for discipline or for dismissal, do you know what burden of proof the evidentiary panel must use to decide whether dismissal or that there was a violation of a disciplinary rule? Do you know the burden of proof?
I apologize, Mr. McKetta, I do not.
I'm going to suggest it's preponderance of evidence. And the evidentiary panel would make a determination after discovery, is that correct?
Yes.
After sworn testimony was available?
Yes.
Cross-examination was available? An adversary proceeding was available?
Yes.
And then on the preponderance of evidence would adjudicate?
Yes.
Just cause doesn't mention any of those things, does it? Discovery?
It doesn't mention discovery, but it does mention
Cross-examination?
investigation.
Oh,
It
yeah.
actually compels investigation.
And its standard is upon reasonable inquiry rather than preponderance of evidence, is it not?
Yes, Mr. McKetta, and you're correct. Your point is correct, that the just cause determination has a different procedure and different bells and whistles and variety of different procedures than the subsequent evidentiary panel. But the fact that those are two different sorts of procedures does not undermine or negate the fact that the statute as structured puts a determination burden and a finality aspect to the no just cause determinations. And I think that the series of letters, as they fit into that rule structure, illustrate it very well. And if you start at tab 1, and it's important to consider these against the backdrop of the case law in the administrative context, talking about when can an agency not revisit, not reopen something that it already looked at and made a decision about. And the two hallmarks that the courts have looked at, and the case law on this administrative law issue, mostly it comes out of the third court, which stands to reason because the agencies are here. I think the two primary cases that are discussed in the briefs are the Sexton case out of the third court that was written by Judge John Powers, who probably wrote some of the most significant administrative law decisions in our state jurisprudence, and another one called Al-Jazrawi that's written by then Chief Justice Shannon. And both of them focus on two issues. Was there a determination, and was it intended to have finality? Does the statute otherwise give the agency the right to go back, to reopen, and have essentially a do-over?
But in both those cases, especially in Al-Jazrawi, there were hearings.
Well, here, you're right. But here, the statutory structure contemplates, here's what in the just cause process, there is an investigation. There's a compulsory response by the respondent. There's a time limit. And that is the procedure that the rules demand.
But we can agree that in the cases you're citing, there actually were hearings, though, right?
Well, in the case about the licensing case, the Al-Jazrawi case, there was an application to be it was sort of a reciprocal licensure. I'm already a professional engineer. I want to be licensed as a professional surveyor. The Board of Surveyors said, we're not going to give you that because the Board of Professional Engineers says your paperwork's not in order.
And you got to pass the exam. And so then they say in 85, he obtained a second hearing before the board seeking reconsideration for licensure.
But what it was an application. All it was an application, and what was turned down, the reason he was turned down is you're not in order. Your licensure status before the Board of Professional Engineers is not in order, and therefore we're not going to give you the reciprocal. So that is not an adversarial adjudication in that regard. That's an application. We're going to turn it down because you do not have the credential that allows you to come in as a professional surveyor. And then later, when he got his paperwork in order, the Judge Shannon, Chief Justice Shannon said, the survey board can't reopen because the statute doesn't say you can reopen, because what they were looking at was past facts. You can't reopen. And the last sentence of that opinion says, these facts have been adjudicated. Well, nothing was adjudicated. It was a presentation of evidence to the board of, what's your status before the professional engineers? Oh, it's not in order? Okay, you don't get your survey situation. But the point is that the rules of of discipline, they contemplate this process that includes an investigation and a determination. You can quibble with whether...
Determination of what?
Just cause or no just cause.
Isn't this like a grand jury indictment more than a determination on the merits?
No, it's not, and here's why. Because there are a number of statutory deadlines built in. There's compulsion on the part of the respondent attorney. It is a violation of the ethical standards for the respondent attorney not to respond. And that's very different from a grand jury where you cannot haul in the subject of a grand jury investigation. There's also, there's no appeal involved from that. There's also a mandatory provision, there's a mandatory deadline, 60 days. There's also a provision that the CDC shall destroy the file after so much time has passed. So if the statute did not contemplate finality, if it contemplated that the CDC could reopen that, even on its own motion, because the definition of complainant includes the CDC, and that's a new provision in the 2004 amendments. The CDC itself, if it could freely be a complainant and reopen at any time, the provision that they shall destroy their files, and in fact that's what happened here, the file from 2007 was destroyed according to statute. If it had been intended that they could reopen and reopen and reopen, then mandating that this file be destroyed mandates that you reinvent the wheel.
Ms.
Doesn't
Weber?
that just mean that each complaint stands on its own and you don't go back and look at the other one? Wouldn't that be a logical conclusion as well?
Except that it's the same issue. Does that make any sense?
Is there a mandate that the file in this proceeding that had an evidentiary panel and an adjudication on preponderance of evidence, is there a mandate that the file be destroyed in 180 days?
No.
Does that not cut backwards on you that where there's clear adjudication, the file is not destroyed, where there's a summary dismissal, the file is destroyed? Doesn't that cut against your argument?
Well, that is Mr. McKetta, as I said before, they are different procedures. And clearly there is a more fulsome adjudication in the evidentiary panel. But that's not the question for this board. The question for this board is whether the statutory structure contemplates that the no just cause determination have finality. And it does, and the series of letters from the 2007 grievance proceeding demonstrate how that's supposed to happen and how that happened here. If you start at tab 1, tab 1 is the first letter where the CDC is informing Mr. Sebesta that the grievance was dismissed as an inquiry. That's sort of a stage 1, that even if you look at it on its face, we're not going to proceed. It doesn't constitute, we don't believe that even if you buy all of the facts, that it would rise to the level of an actionable grievance. And they said why? Why do we think this is an inquiry? They said because of limitations, because of the bar of limitations. So at that point, it is appealed directly, and then you turn to tab 2. Informs Mr. Sebesta that the complainant has appealed the dismissal as an inquiry on limitations grounds, has appealed that to this board. It didn't go first to the summary disposition panel. It came to this board, and I'm going to get to the summary disposition panel issue in a minute. So it's appealed to this board. What is appealed to this board? Dismissal as an inquiry on the basis of limitations. That's the express statement for the dismissal as an inquiry on the basis of limitations. Then you turn to tab 3. Tab 3 is this board's determination, and it reversed the dismissal. So what does that mean? This board determined that the complaint was not barred by limitations. And we know that had to be a determination on limitations because that was the stated basis in tab 1. That was the stated basis for the dismissal of the inquiry on limitations. And then it came to this
You
board.
think this board is limited to that stated basis alone, or the disciplinary rules as a whole?
Well, Mr. Johnson, certainly this board, it would be great for the system if this board looked at all of the different aspects of an issue that came before it. But when it comes before you on the question of limitations, if limitations is right, then that's how limitations work. You don't even reach the merits. So this board necessarily had to have determined that the dismissal on limitations grounds was incorrect. Because if limitations on dismissal for limitations is correct, then all the merits in the world don't get you there.
But is this board limited to what's stated in the appeal, or can it use the whole body of disciplinary rules when it turns something around?
Well, this board can look at the whole body of disciplinary rules, but when there is a dismissal on limitations grounds, you've got to decide that one first. Because a truly meritorious complaint that is barred by limitations is barred by limitations and can't go forward. And so this board would have had to have addressed the threshold question of limitations before it could have gone on to others. So
The counsel, couldn't the board have determined there was a fact issue as to statute of limitations?
it is unlikely. It's extraordinarily unlikely given in this instance, in this file, because the application of limitations at the time was sort of a bright line.
Limitations is not always a bright line. In fact, as I look at Exhibit 3 and the different rules cited, it looks to me like the board was looking at a wide variety of conduct and whether there was a bright, whether it was clear whether the statute had run.
All of those references are to trial conduct. All of the factual allegations regarding Mr. Sebesta are trial conduct in 1994. And in 2007, the application of limitations in the grievance process was a bright line 4-year from the trial, from the conduct. And so in response to Mr. Johnson's comments, the board clearly went further and looked at the substance, but it had to have decided limitations as the threshold question and reversed the dismissal on limitations grounds. And
Let me just stop you right there because I'm trying to understand your argument. If limitations was not involved in this matter, let's just assume there are no limitations issue, and things had turned out the way they did, would you still be saying this was a final disposition for res judicata?
absolutely.
So whether it's limitations or something else does not matter.
It absolutely does not matter.
Thank you.
Let me ask you something just in terms of how you see the public administration of discipline of lawyers accused of wrongdoing. Suppose there is an accusation brought by an inquiry or a grievance that has to be determined. And suppose I, as a lawyer, then am called to respond and do so. And suppose I give false information. But based on my false information, the screening committee, on their reasonable inquiry, looks no further and finds that there was no just cause and dismisses. You've got that scenario. And suppose a month later, somebody realizes, no, there really are some things that were not accurate when Makeda gave his response. Are you saying Makeda now is free and clear of the underlying problem, even though he could now be grieved against for a false affidavit? You're saying that the past offense can never be looked at again because the screening at a reasonable inquiry level didn't test further.
Yes, Mr. McKetta, and here's why.
In a grand jury, you'd agree that would not be the result. In a grand jury, there could be a re-indictment after a no bill, time after time of a no bill, there could be a re-indictment on the same facts.
Yes, those are different proceedings. And there are a number of hallmarks of finality that appear in the process of the no just cause determination. One is that the statute there's a statutory mandate that the CDC shall investigate. So the CDC at the just cause stage, at the grievance stage, complaint stage, does not just take the word, just take your word.
Does it have
when you come in.
subpoena power at that stage?
It does not have subpoena power.
Have power to require witnesses to be sworn at that stage?
It has, no, they do, I do not believe that they do. They have the,
So it has power to interview and do background investigations just as a prosecutor might do before deciding to present to a grand jury?
correct,
Okay.
correct. But there is a statutory mandate that they shall investigate and they shall determine whether just cause exists. There's mandatory timing involved, so the statute contemplates they've got to get after it. This cannot go on forever, and the respondent attorney has 30 days to respond, and then the CDC has 60 days to make its determination or not. If there is a finding of no just cause, then it goes to a summary disposition panel. It doesn't, that's not just the end of it. So it's not just the screening process. It then goes to a separate body to review that. And
But let me ask you, the fact that the body that then reviews it, which is a summary disposition panel from the grievance committee, all they can do is say yes or no. They can't penalize anybody. They can't do anything other than saying it's dismissed or no, we think you should go further. Doesn't that argue against it being a final adjudication?
no, it doesn't, because that's someone else grading their papers. It's not just an internal CDC determination. And the summary disposition panel is new. That was also added to, that didn't exist in the pre-2004 statutory scheme. That was added in. And that is another set of eyes looking at, and presumably the summary disposition panel, in doing its job and not just being a rubber stamp, would look at not just they found just cause, no just cause, okay, fine. What did your investigator find? Who said what? So, Mr. McKetta, it's not just dependent wholly on did I give false testimony, but what does the fulsome investigation show? And then at that point, there is no further appeal and the file gets destroyed. And I think the timing issue is an important one to bear in mind. Last summer, and that the timing issue, of course, is that the CDC has to make its no just cause determination within 60 days after the respondent attorney's time to respond has passed. And that is a mandatory statutory deadline. Last summer, in July of 2015, there was argument before this board, and one of the issues presented in an appeal was the question of whether that 60-day deadline was jurisdictional or not. And, in response to a question by Chairman Kittner, Ms. Hamilton explained to this board that it is not a jurisdictional issue, but it is mandatory, and it's important to keep up with it. And if the 60-day deadline were not complied with, then at that point, the evidentiary panel would need to make inquiry and ask, how did this come to pass? Why did you not comply with it? And has there been any harm? And the question of harm, Ms. Hamilton explained, and I agree with this, if a just cause finding were made 3 years later, there could be obvious harm to the respondent. And what we have here, essentially, is 7 years later. There was a no just cause determination in 2007, and then 7 years later, the exact same set of facts was revisited.
Ms. Weber, I can't follow that. If that had never happened 7 years ago, under the current rule 15 on limitations, it could come up today, years and years and years after the facts. How did that intervening hearing prejudice the results of an investigation today?
Ms. Webb, before you answer that question, I want you to answer the question, but then I'm going to conclude your part of it. I'm going to give you some time in rebuttal, but you're already 5 minutes past your time, and this is an important issue, and we want it fully developed. But go ahead and answer Mr. McKetta's, and then we'll hear from Ms. Hamilton.
Well, Mr. McKetta, you're right. You're right that the passage of time can make it more difficult for anybody, for a respondent attorney. But where you have an instance like this, where there was an opportunity, there was a determination, there was an investigation, then there was a snapshot in 2007, an opportunity to analyze this. The board analyzed it, the bar analyzed it, determined there was no just cause, and 7 years of passage from that time is a relevant inquiry for this court, and we submit that's we agree with Ms. Hamilton that surely harm, and there's an obvious harm to the respondent in that delay.
Thank you.
May it please the board. Good morning. The board should affirm the judgment in this case for 2 reasons. 1, relevant authority does not support Mr. Sebesta's position that the evidentiary panel erred by denying his pretrial motion to dismiss. And 2, throughout the proceedings below, the Chief Disciplinary Counsel's actions were squarely within both the letter and spirit of the disciplinary rules as well as the State Bar Act. So first, let's look at the legal authority that was presented by Mr. Sebesta in support of his position. And remember, the only issues that are properly before the board in this appeal are whether Mr. Sebesta proved his res judicata defense and proved his estoppel defense. Those were the only issues that he raised in the motion that the evidentiary panel denied. And when he filed this appeal, he intentionally decided to limit the issues that he could raise. In his notice of appeal, he said, respondent intends to limit his appeal to only the panel's rulings on the legal issues raised by respondent in his motion on res judicata and estoppel. And because he decided to limit his issues, he filed a partial record. And so we know from the rules of appellate procedure that now he's limited to the issues that he raised in the 4 corners of that motion that the panel denied. So those are the 2 issues that are fair game for this appeal, res judicata and estoppel. And there simply is no authority for his res judicata argument. There is the proposition that an agency's non-adjudicative preliminary determination not to move forward on a complaint, the idea that that could serve as a permanent bar to any future consideration of the matter addressed in that complaint, as well as all related matters, is not supported in the law.
Would you help me understand the authorities that have addressed res judicata in this context, like Rogers? Is it correct all of those predate the changes that Ms. Weber was referring to?
That is correct.
When you say that their authority, would you agree that this is a question of first impression?
This is somewhat a question of first impression because the rules have changed since those decisions were handed down. I think the most recent was a 2004 decision, and it was decided under the old rules. That was the Rogers case. But if you look at those changes, it's clear that the grievance committee, under those cases, under the old system, the grievance committee that was responsible for screening grievances and determining whether they should proceed to litigation, those grievance committees had a lot more authority than is provided to CDC under the current rules. They could take testimony under oath. They could compel witnesses to appear. They could require the production of evidence. The respondent attorney could have the grievance committee compel witnesses to appear and produce evidence on his behalf. And also, importantly, the failure to comply with a grievance committee order to appear or to produce evidence, that was punishable by contempt. Now, CDC, under the current rules, has none of that kind of authority. It's clear that all of CDC's authority is investigative authority, and it's a very limited authority. CDC cannot subpoena any information. CDC cannot compel witnesses to appear. CDC hands are essentially tied. And CDC, as Ms. Weber pointed out, has a very strict deadline for making a determination of just cause. So because of those restrictions, it's inevitable that incorrect just cause decisions are occasionally going to be made. So sometimes CDC can and does revisit matters that might have been addressed in grievances or complaints that were previously dismissed.
If you say occasionally mistakes are made or revisiting occurs, what would be wrong for administration of the responsibilities of CDC if the rule were that a finding of just cause closes the matter? What would be wrong with CDC whenever there's a close call making the decision to go towards the evidentiary panel with a rule that they were foreclosed if they found no just cause?
Well, that would be the better decision, probably, than deciding that we're not sure, and so we can't really tell if this is something that should be dismissed or something that should go forward, so we're going to go ahead and err on the side of moving forward. That would be the better decision than just letting potentially serious misconduct go, if that's the only opportunity to look at it. But at the same time, is that really the best outcome? Because what would happen then is we'd move into full-fledged litigation. CDC would have to go through litigation. The respondent attorney would have to go through litigation. The expense, the resources that go into that, not to mention even the stress of the respondent attorney being put through that, sometimes needlessly.
Well, for Mr. Sebesta's point would be, would it not, that he has had to go through this twice, the expense and the stress that you describe, and what would be wrong with a determination that when that stress and expense has brought things to a head one time, either one goes forward to look to see if there's discipline or one brings it to closure by a finding of no just cause?
Well, in this is a unique situation, remember, because in this case, there was a major change that enabled CDC to move forward on the Graves grievance when CDC couldn't move forward on a similar grievance that was filed by Mr. Bennett.
Ms. Hamilton, I think what we're looking for to some degree are what are the public policy reasons why we should adopt your interpretation here. And so just from a matter of not just Mr. Sebesta, but on overall public policy, you've been asked several questions about going back and revisiting. What are the public policy reasons that would support or permit that?
Well, CDC's real purpose, why the disciplinary system exists and why CDC implements the disciplinary rules the way it does, is to protect the public. That is the overarching goal here, to protect the public from attorney misconduct. If, in light of CDC's hands being so tied during the investigative phase, CDC having little investigative authority, if, as a result, CDC were unable to make correct just cause determinations and could never revisit those issues, it's inevitable that there would be cases of misconduct and serious misconduct that would not be able to be addressed effectively. Now, not only would that happen, but there would actually be an incentive for attorneys not to cooperate in the investigative phase. Now again, we can't compel them to cooperate. Yes, there's a rule that says if they don't respond to us and respond to the grievance, then disciplinary action can follow simply for the failure to respond. But that doesn't mean we can compel them to respond. We can compel them to provide information. We can't compel anybody to do that during the investigative process. So inevitably, we would miss cases of misconduct. We wouldn't be able to address those. And again, attorneys would actually have an incentive not to be cooperative during that just cause phase so that we could reach the right result and get to a just resolution.
So if they achieved a no just cause finding, it then becomes almost sort of a pardon for that conduct, at least in terms of disciplinary rules.
Absolutely. And, it wouldn't even necessarily be unethical for an attorney to act in that manner and just hold back on his level of cooperation during that process. He doesn't have an obligation here to prosecute himself. So that, inevitably, we would see that in some cases, not all cases. I would want to assume that most attorneys would still be very cooperative, but there are some that would not. And I would assume that those who do not often would be the ones involved in the most serious cases involving the most egregious allegations of misconduct. Mr. Sebesta's cases, they presented instances where the process that resulted in a final decision was just very different from CDC's investigative process during the just cause phase. They involved witnesses and adversarial hearings, agencies that were able to enforce their decisions, opportunities for full judicial review of those decisions. Those attributes were not present here because they're not part of the disciplinary rules during this phase of the process. In addition, as mentioned, the Commission presented several cases that do answer the question whether res judicata or some other bar finality attaches and prevents CDC from revisiting an issue later because of a no just cause decision. The rules have changed since then, but the new rules provide even more of a basis for that same conclusion, that res judicata simply does not attach at that point in the process.
Let me stop you there. In reviewing the materials, it appeared that the CDC, and specifically Ms. Acevedo at various points, said the early 2007 grievance was solely on the basis of limitations. Is that fair to say that that's what the record reveals?
That is fair. That is conclusively established at this point.
And when I was asking Ms. Weber whether that made a difference, she said it doesn't. Do you agree with that?
Well, I think their briefing on page 29 says if it was adjudicated on limitations, they give the malpractice case.
Well, I'm just trying to understand whether you believe, as opposed to, and I defer to Mr. McKetta, but whether the basis for the dismissal, because the way the system works is if there is, it goes back to the, on an appeal to us, and we look at the file and say, no, we think there is enough to proceed, and we send it back. We will cite the rules, but when you dismiss it, you don't necessarily say why. Isn't that correct?
That's correct.
Here, there is a specific reason given, and I'm just trying to understand if it makes a difference in your argument, if that makes a difference in the outcome here.
If a case were dismissed on limitations and a subsequent grievance were filed based on that same conduct, presumably limitations would apply again and cause CDC to be unable to prosecute that grievance successfully, so presumably we'd have the same result. It would be dismissed the first time based on limitations and dismissed the second time based on limitations. Again, we have a very unusual situation here, and it's hard, that's not an issue, it's a hypothetical that you're presenting to me, and it's a complicated hypothetical because the change in the statute of limitations we have here was a very unusual change. It wasn't just a change from 2 to 4 years, for example, or 4 to 6 years. It created a new opportunity for discipline in a circumscribed set of cases. So it's a complicated question.
But Mr. Kittner's question could arise under the old statute, which allowed 4 years unless there were fraudulent concealment, and there was other discovery things, but I'm focusing on fraudulent concealment. You could have an adjudication based on limitations not knowing of the fraud steps taken to conceal. At a later time, if it's determined there had been fraud in concealing certain information, would the first adjudication already foreclose anything else? Would the first, and then I'm going to switch to would the first finding of no just cause foreclose anything else?
I have to to admit that's not a question that I'm prepared to answer. My inclination is probably if there were fraud and concealment, then yes, we would be able, the limitations decision would not bar a second look at that issue, even if it had been adjudicated completely. But that's not an area of expertise for me and not something I really thought about before this argument. If it is a pivotal question, it's something that we could address post-argument.
I bet you've thought about this one, the blue. What credence do you give to the finality of exhibits 1 through 6?
Well, I think the point of the blue book, the exhibits that are included in the blue book, that the point is the point that Mr. Sebesta has made many times in this case, and that is, he says he was told that the grievance, the 2007 grievance, was dismissed on its merits, and therefore it wasn't dismissed on limitations, and we're not telling the truth about that. But based on the record, a more reasonable interpretation of those documents and other similar evidence in the record is that CDC never told Mr. Sebesta that it investigated the Bennett grievance and determined that there was no basis for a reasonably intelligent and prudent person to believe that he had committed professional misconduct. Now, based on the evidence that was presented to CDC, that wouldn't even have been a reasonable conclusion. CDC didn't say that. It was Mr. Sebesta's own flawed analysis of the construction of the term just cause that led him to that conclusion. And if you look at the definition of just cause, the plain language of that just cause definition tells us that CDC may make a no just cause finding if CDC determines that limitations is a bar. That's one of the options. CDC could find no just cause because it investigates a grievance, all the allegations, and determines that there's just nothing to support it. That's what happens in most cases where there's a no just cause finding. But CDC could also determine there's no just cause because limitations applies. And again, as we stated in our brief, based on just the Fifth Circuit's opinion standing alone, it would not have been reasonable for CDC to conclude there was no just cause on the merits of these allegations, and that is not what CDC concluded here. Now, the other question, and it's a belated accusation of sorts that Mr. Sebesta raises in his reply brief. He says he's very heavily focusing on this argument now that CDC supposedly acted beyond its authority when it moved forward with Mr. Graves' grievance. But the truth is, as I said in my opening, CDC's actions in this case were squarely in line with the letter and spirit of the disciplinary rules. If we look at Rule 2.10, it says, and I'm quoting, CDC shall within 30 days examine each grievance received to determine whether it constitutes an inquiry or a complaint. And then if you look at the definitions of inquiry and complaint, what's clear is that CDC has to upgrade a grievance to complaint status if it alleges conduct that, if true, constitutes professional misconduct under the disciplinary rules. Now, in this case, the Graves grievance did plainly allege conduct that would constitute professional misconduct under the disciplinary rules. And so based on the rules, the grievance was properly upgraded to complaint status under Rule 2.10. And a response was requested from Mr. Sebesta. Now then, if you look at Rule 2.13, the next step is for CDC to investigate, again, with very limited investigative authority, but CDC has to investigate and determine whether just cause exists. In this case, based on the Graves grievance, because we're talking about 2014, CDC found just cause, and it did it because unlike the Graves grievance, unlike the Bennett grievance in 2007, there was no bar to prevent disciplinary action. So in making the decision to upgrade the Graves grievance to a complaint, and in finding just cause, CDC proceeded precisely as the disciplinary rules required. There was just no provision that provided for the dismissal of Mr. Graves' grievance, and in fact, dismissal wasn't required, as Mr. Sebesta urges. There's no provision that says it was required. And, it doesn't even look like dismissal would have been authorized under these circumstances because, again, the limitations bar was gone. The legislature had removed that. Now, it's not true that CDC yielded to political pressure in making this decision. That's not what happened. CDC did what the rules told it to do. It was the legislature that yielded to political pressure, and the legislature gave CDC its marching orders and said, you're going to look at these grievances if they're filed within 4 years of the wrongfully imprisoned person's release date, and that's what happened here.
Ms. Hamilton, could you comment on the discussion of the 180-day rule for destroying file? Where does that take you?
Well, it's an unusual provision. It's one that we sometimes struggle with in our office. I don't think it has any bearing here. I envision that in some cases, where there might be a valid, some kind of a valid complaint about revisiting an issue that was raised in the past, the files would be gone, so it might make some kind of a raised judicata argument difficult for a respondent attorney to make, or difficult for an evidentiary panel or CDC to evaluate, because files may be destroyed even when a case goes all the way through the litigation process. There's a provision in the State Bar Act that allows for the expunction of records once a case goes before an evidentiary panel and is dismissed.
Well, your time is up, and if I have one more question to follow up on what Mr. McKetta said, to me, it's not so much the fact that you can't get the records or anything like that, but I understand the argument to be destroying the record is evidence of the finality of it. That shows that you're through with it, it's over, it's done. What is your response to that, as opposed to, yeah, it could be a hardship and a burden, I get all of that, but what is your argument to hers that, as I understand it, that shows that you were through with it? Done.
Well, there are 2 points that I'd make in response to that argument, and one is that you can't take that provision that allows for the destruction of the file out of the context of the rest of the statute that makes clear that these decisions are not final. They just don't have the attributes of a final determination. In addition to that, even under the rule that allows for the destruction of these files, even grievances that are never upgraded to complaint status, grievances that come to us and they don't look like they allege professional misconduct on their face, grievances that we decide not to upgrade and we classify as inquiries, those are also destroyed. So in every case then where we barely even looked at a grievance, would we be foreclosed then from addressing what could turn out to be very serious misconduct? And it just so happens that we received this information at a point where the grievance just wasn't right for us to move forward and do our job effectively? No, of course not.
And the 2007 grievance here was an inquiry, was it not?
It was classified as an inquiry, yes, and then the board did reverse that decision and tell us to investigate.
Anybody else have any questions, board members? Thank you, Ms. Hamilton.
Thank you.
Ms. Weber, you have 5 minutes.
Thank you, Chairman Kidner. I'd like to make 3 points in brief reply. First, on the question of limitations. Ms. Hamilton said that the record conclusively establishes that the no just cause determination in 2007 was on the basis of limitations, and that is simply not so. There is an affidavit that says it was on the basis of limitations, but the series of letters in this booklet demonstrate otherwise. And I think the question you asked me earlier, Chairman Kidner, is limitations an issue, and I said no. And I think that the question of limitations here implicates the law, the facts, and the karma. On the question of law, whether a determination was on the basis of limitations as opposed to a determination on the merits in the Texas law doesn't make a difference. That is an adjudication on the merits. The Eigel against Bright Star case that is cited in the briefs is a Supreme Court of Texas case in the context of an administrative decision, and the court says expressly a dismissal or a decision on the basis of limitations is a determination on the merits. So as a legal matter, it doesn't matter. As a factual matter, if at tab 4, we have this board reversing the dismissal of an inquiry on the basis of limitations. So, as we discussed earlier, Mr. Johnson, as a threshold matter, this board had to have decided that limitations was not a bar, reversed that
Or that there
dismissal.
were fact questions about that, such as discovery rule or fraudulent concealment.
Well, those are not implicated.
That it had stated a claim without dispositively showing that it was time barred.
But there is no implication, those cannot apply under this fact pattern. Those simply do not apply under this fact pattern. This was after the Fifth Circuit opinion. This is 13 years after the trial, and all of factual allegations are regarding the conduct at trial. So that cannot have been. But even if it were, Mr. McKetta, what this board did is reverse the dismissal on the basis of limitations and remand it with an instruction, the board shall investigate. And then it goes back, and then it goes through the whole process. They ask Mr. Sebesta to respond. They perform their investigation. They say, we are performing our investigation. And then they make a determination of no just cause. So either the CDC flouted, thumbed its nose at this board's reversal on the basis of limitations back in 2007, or they are not being truthful with this board today in saying that the dismissal was on the basis of limitations. And under either scenario, that does not reflect well on the bar.
Can I ask
You
a
had
question?
points. Go ahead, Kathy.
So I want to give you a hypothetical so I can better understand this. Let's say there are 6 defendants in a case where there's prosecutorial misconduct. Forget about the statute of limitations. 2 of the 6 file grievances in the first year. And whatever they say in their grievance doesn't raise anyone's level, anybody's decision-making to a level of that misconduct. And then within the 4 years, one of the other defendants writes a whole lot better complaint, and that does get everybody's attention, and there is an investigation and prosecutorial misconduct is found. Are you trying to tell me, and all of us, that because some other complaint that some other defendant wrote bars one of the other defendants from setting out more and more facts? And if that's the case, how did Mr. Graves give Mr. Bennett the authority to bar him from filing a grievance?
Well, I think your hypothetical raises several points. The main answer is no. It would not bar it. And actually, the Stern case addresses a similar factual scenario where there were complaints regarding 5 individuals, and the CDC dismissed the grievance as to 2 because it had already previously dealt with them and found no just cause and proceeded on just the other 3. And there was some discussion of, well, is the prior dismissal as to the 2, does that preclude the 3, and the court allowed it to go forward? And that's a decision out of the first
Which is
court.
exactly the opposite of what you're arguing here today.
No, it's not, Your Honor, because we don't have a difference. We have only one trial with one criminal defendant involved. We have only the allegations of Mr. Graves' underlying trial. We don't have Mr. Graves and other people. And as far as the question of Mr. Bennett raising the issue versus Mr. Graves raising the issue in the 2 different proceedings, I would note as a factual matter, Mr. Bennett was Mr. Graves' part of his legal team in 2007, and Mr. Bennett is actually the one who electronically filed Mr. Graves' 2014 grievance. And so there, as a factual matter, Mr. Bennett is involved in both, even the one that Mr. Graves signed, but that doesn't matter because complainant can include anybody, including the CDC sua sponte. It could have been the trial judge, it could have been a bystander, it could have been someone who read something about it in the paper and was offended. It could have been anybody. So the precise fact of who files the piece of paper that is a grievance that starts the process doesn't implicate whether at the back end. And we don't have a situation like you paint, where one person can bar somebody else. But under the Stern case, one person cannot bar somebody else. And I would note the final area of discussion in the Stern case addresses res judicata from a finding of no just cause. And the court determined that res judicata did not apply because, as I said before, the two were dropped out. The two for whom there had been a no just cause determination were dismissed, and 3 others who never were part of a no just cause determination, those were the only ones proceeding, and so the court distinguished it on that basis. And the court also said that the respondent attorney had not pled and proved res judicata. But what the court did not do is say, as a categorical matter, res judicata does not apply to no just cause determinations by the CDC.
Mr. Chair, Ms. Weber had said she had 3 points. We kind of distracted her after she got to the limitations. Could we give enough time to briefly outline
Only
the other
because
two?
it's Mr. McKenna, I'm going to defer to him, but,
Thank you, Mr.
we're
McKenna.
already
Yes.
way past your time,
And-
so
and
we're
I-
not going to ask you any more questions, but I ask you to sum up your other 2. Thank you.
Second, regarding the policy issue, the parade of horribles that Ms. Hamilton said that if the no just cause is going to be final, then you might have respondent attorneys refusing to cooperate in hopes that they can get a pardon. Well, if that happened, if you had a recalcitrant attorney not cooperating, then that certainly seems to me to justify finding just cause. So you don't have a situation where, oh goodness, our hands are going to be tied and we're going to have to let all these people off and out on the street. If someone does not cooperate with you and you're unable to make a fulsome investigation and determination, well then find just cause at that point and put that recalcitrant attorney to the next stage of burden. And finally, I think you might have asked whether this was a question of first impression.
Mr. McKenna.
Mr. McKenna, whether this was a question of first impression, and I think in a way it is, certainly to this board, regarding the issue of what is the preclusive effect of the no just cause. I would point out that the Stern case does not think that this is as a blanket matter, and this is Justice Jane Bland who wrote this, who I think enjoys a well-deserved reputation as a jurist, and I think that it is important for this board. Sometimes I've gone back and I've looked at a lot of this board's decisions, and sometimes this board makes its decision in sort of summary sorts of orders, recital of procedural history and affirmed or reversed in sort of a paragraph. But I think given the importance of having this issue resolved for all purposes on a going forward basis, I would urge the board to write fully on this, no matter what the decision is, and we urge the board to reverse the judgment of disbarment on the basis of the 2007 finding of no just cause.
Thank you very much. We appreciate the arguments both sides. We'll take it under advisement and let you know of our decision as soon as possible.